Welcome back. The move by some electorates to recall Senator Dino Melaye has continued to generate reactions. Some lawyers say that the leadership of the Senate missed the point when it declared that the Senate has a role to play in the recall process. Though INEC has suspended the recall process for now in deference to a court order on the issue, we have the views of some lawyers on whether or not the Senate has any role in the recall of a lawmaker.
The Constitution is clear in Section 69. The whole provisions of the Section 69, there are two subsections there, Sections A and B. A says if any member of the House of Representatives or Senate wants to be recalled, all the constituency needs to do is to sign a petition and send it to the chairman of Independent National Electoral Commission. And those who sign the petition must be more than half of registered voters, not voters. And the Senate is not there in that provision. The second provision is that after that petition has been submitted, the INEC now will now conduct a referendum of people who will be present to say yes or no. And once that is done, INEC eventually will now say, okay, they will issue a certificate of recall, which they have issued in their own guidelines. Then once the certificate of recall is issued to the person who is concerned, that's all. They forward a copy again to the Senate President, and all that is needed of the Senate President is to swear the person in.
As far as I am concerned, and looking at the Constitution and the Electoral Act, the lawmakers have no right whatsoever to play. It's strictly electorate affairs. They were the ones who put them there. The powers belong to the people, not to the Senate or the House of Rep. In the event that a particular lawmaker elected on the platform of any political party and is not representing interest, the Electoral Act is very clear. And it has specific rule. Once they are able to gather enough signatures of those who voted within that constituency, then the call can start. And that's what they can do. If going to the court is just a short of time, unless that it can prove fraud. If the elected House of Rep member or Senate can prove that there were fraudulent means of obtaining those signatures, then the court will listen to him. If not, power resides with the people, with the electorate.
They should apply to INEC with a certain number of the percentage of their electoral who are registered in that constituency. And once that is done, INEC within that number, 90 days, to go back and verify. And once INEC is satisfied, they conduct the referendum. And his recall, that is if INEC is satisfied. If the only way the senators can go to court is that if they bypass the INEC or did anything that is not in consonant with the provision of the Constitution, they can go to court. But no court can stop that action because it's not provided. Have they violated his right? Is it not the constitutional right of the constituency? It's their constitutional right. The Constitution provided recall and bring application to INEC. And INEC is to follow it. INEC has come out that the years they have brought and they are reviewing it. That is correct position. No court can do that.
The position of the law is as stated by Dr. Abubakar Bukola Saraki, that whatever they are doing at the Kogi level and Kogi West and INEC activities will still have to be brought to the Senate of Federal Republic of Nigeria for them to perform their constitutional role in respect of that recall exercise. Without that, the exercise itself will be seen to be incomplete. And I say this with all sense of responsibilities. You will recollect the issue of local government creation in Lagos State. While the state was doing its LCDA at that time, the question that aborted it from being listed in the Schedule to Nigerian Constitution 1999, and which will make the local government to have the power to have money appropriated for them from national account, is the fact that whatever they have done at this level has to be taken to Abuja for this to be listed. If it is then listed, and then it now has power to get money appropriated for it as a local government of Federal Republic of Nigeria, and that if they have not done that, the council so created by Lagos State is inchoate. Don't let anybody fool anybody. The wording of that constitutional provision is very clear, that when you finish all your activities, you will bring it to Senate. When they are convinced, then they know the step forward. As a matter of fact, that law is very clear. The Senate President has a role to play. The law is very clear. Don't let anybody tell you that he's a constitutional lawyer. No lawyer makes constitution in the sitting room.